So let's get started. It has been a few months since I've done one of these. Let me see, gotta share my screen first. Share, nope, this one. There we go. Share, all right. Slideshow, play for start. Okay, so just for those of y'all, no, just a second. Sorry, just a second. Actually, unplug something here. Okay, there we go. So, sorry, let me get this pulled back up. But for those of y'all that don't know me, my name's Kyle Farmer. I'm the owner of Farmer Law PC. The main thing that we do is we work primarily with agricultural employers and advising them on how they can leverage immigration law to fill labor shortages within their company. So that's who we are. Let's talk a little bit about just high level, what is H-2A? Now there's going to be a little bit to unpack here. So what's the H-2A visa program? It allows US employers who meet specific regulatory requirements to bring foreign nationals to the US to fill temporary agricultural jobs. One thing to be aware of is what is classified as agricultural jobs and what is not as easy to understand as one might think. You know, what we associate with the word agriculture is not necessarily what the regulations associate with the word agriculture. Agriculture is defined in the H-2A regulations are adopt the definitions of agriculture under the IRC, the Internal Revenue Code, and under the Fair Labor Standards Act. So under the Internal Revenue Code one's really specific, but the secondary or the definition of agriculture under the Fair Labor Standards Act is not nearly as specific. But the one that people pay most attention to generally is the definition of secondary agriculture under the Fair Labor Standards Act, which is work that's being performed on a farm or by a farmer as an incident to or in conjunction with the primary farming activity. I think I quoted that correctly. I don't have it in front of me, but those are basically the two elements that you would want to pay attention to. Is the work that's being performed, is it being performed on a farm or by a farmer? That would be one of the elements. The second element would be as an incident to or in conjunction with the primary farming activity. And then primary farming activity is specifically identified in the Fair Labor Standards Act to include things like the production of crop, the raising of livestock, those sorts of things. So you would want to check those two elements to determine, is my work agriculture? Generally, that's the definition you'd look to, unless it falls under the very specific definitions of primary agriculture, which, you know, a lot of times crop farmers and livestock growers do. But yeah, is it work that's being performed on a farm or by a farmer? If the answer is no to that. So a good example of that, where that comes up all the time, is let's say that I own a trucking company, and my trucking company, I'm not a farmer myself, but the only thing I haul is grain. After grain's harvested, I pick it up, I take it to a co-op, and that's my entire business. Many people, and historically, that had been recognized as agriculture, but there was a case, I guess it was a couple years ago now, where the Department of Labor said, wait, that work is not being performed by a farmer, that work is not being performed on a farm, therefore it's not secondary agriculture. And it has huge implications because one of the primary requirements of qualifying for H-2A is that the work be an agricultural job. So whenever you're thinking of the different aspects of your business, be thinking about, okay, first of all, is this agriculture? If it's not, it gets kicked out of the H-2A program. If it is, we want to talk about how we can make it work within H-2A, because H-2A is awesome. So who qualifies for H-2A? To qualify, a petitioner, a company. There's a little bit to dissect there too. What is a company? A company is a business that's legally authorized to work. And this is the one that comes up all the time, especially with small farmers that don't have an FEIN. You need an FEIN to qualify to to bring up H-2A workers. So it's an employer or a company is any person, which is an individual, partnership, association, corporation, cooperative, firm, joint stock company, whatever, that has a place of business, a physical location in the United States, so that it can be contacted for employment, has an employer relationship, such as the ability to hire, pay, fire, supervise, otherwise control the work of an employee, and has a valid FEIN. So the FEIN is important. So if you don't have an FEIN and you intend on applying for H-2A workers, get an FEIN. So you need to be able to demonstrate that there's not enough U.S. workers who are able, willing, qualified, and available to do the temporary work. This is done through actually, let's kind of combine these. So let me offer a job that's temporary or seasonal in nature. Let's unpack that a little bit. So we're gonna get kind of into some nitty gritty here. Whenever you're thinking about a job that's temporary or seasonal in nature, people really get confused by what this means. The definition of seasonal, which can be found in 20 CFR 655 103D, seasonal is work that is tied to a certain time of year by an event or pattern, such as a short annual growing season or a specific aspect of a longer cycle, and requires labor levels far above those necessary for ongoing operations. You'll notice it says far above. That's very important because a lot of people, whenever they first reach out to us and talk about H-2A, and they think about the word seasonal, they think my work's not seasonal. I'm busy year round. But that's not the end of the inquiry. What you want to know is, okay, am I busier due to some specific event or pattern? Am I busier during a certain time of year for this particular job? And that's an important thing too. So you'll look at the job and then look if there's any seasonal fluctuations within there to determine if it's an actual seasonal job. Now, temporary is an interesting one. Temporary filings are much more rare than seasonal filings, but they come up quite regularly. An example of a temporary filing is if I'm a livestock grower and I have a storm come through and knock down one of my confinements. And unfortunately, this causes a lot of damage, not only to the building, but to the animals. And we need to remove some animals. They need to be moved to a different location while we reconstruct the livestock confinement, and then we need to repopulate the building. There's a very good temporary argument there, even if the work is not necessarily seasonal. So the work might not be seasonal, and that the removal of livestock and stocking of livestock into a confinement not be a job that's seasonal in nature ordinarily. However, because of these certain circumstances, it is temporary because you only need it for a short duration. And then, for temporary jobs, just so you're aware that they are generally less than a year, except for under extraordinary circumstances. Now, a storm coming through and tearing down your livestock confinement would be considered extraordinary circumstances. So if it took longer than a year, that's not a problem. You should have to be able to demonstrate to the Department of Labor. Okay, so now these next two elements I want to kind of pack together because they're done at the same time. So demonstrate that there are not enough U.S. workers who are able, willing, qualified, and available to do the temporary work. And you must show that the employing H-2A workers will not adversely affect the wages and working conditions of similarly employed U.S. workers. So you do this whenever the job is posted with the state workforce agency. Remember, with H-2A filings, whenever you file an H-2A application, you are advertising the job to the U.S. public saying, I will hire any able, willing, and qualified U.S. applicants to fill this role, should any apply. Now, it seems pretty rare that people apply these days, or whenever they do, it's hard to get them to actually commit to the job. That is definitely an issue. But that is what you're doing whenever you're applying with the state workforce agency and the state workforce agency is posting the job on their system. And then show that the employing H-2A workers will not adversely affect the wages and working conditions of similarly employed U.S. workers. This is why you pay the adverse effective wage rate, which is a wage rate that's determined by the USDA. Every year takes basically what it does is it takes the cumulative average wage of agricultural workers in your state and says, this is the average wage rate. This is the one that won't adversely affect the U.S. workers. So that's why you pay your H-2A workers. And now this is important. You pay your H-2A workers and similarly employed U.S. workers at least the adverse effective wage rate. So that happens a lot of times where people have permanent workers who are paid less than the adverse effective wage rate. They'll bring in H-2A workers, and the H-2A workers are performing the same job function as the similarly employed U.S. workers, yet the H-2A workers are paid more. You can't do that. You have to move up your permanent workers to be consistent with your H-2A workers. Now, all this work and determining your eligibility for H-2A or the applicability of H-2A in a specific aspect of your business, it's definitely worth it because of this next point. There is no numerical cap. That is a huge deal. That is one of the things that make H-2A so incredible, is that there is no numerical cap. What that means is that the government will issue as many H-2A visas as are properly petitioned for. So as long as you go through the proper application process, and the government will issue the H-2A visas. That's a really good thing. And really, it's the only thing that makes sense. I still have yet to hear a good argument for a numerical cap on any visa, specifically any temporary visa where you go through the process of demonstrating that you're not adversely affecting the U.S. workforce. If you're demonstrating that you're not affecting the U.S. workforce, there is no logic to a numerical cap. The numerical caps are generally just a political token that are used for negotiation, but they're not practically important. They're not useful in any conceivable way, at least that I've seen. If you have an argument for it, please send it to me, because I am very interested in hearing a perspective of why a numerical cap makes any sense, especially in a visa application that goes through annually where you're required to demonstrate that you're not adversely affecting the U.S. workforce. It makes no sense to me. But anyways, this has allowed in 2021, over 250,000 H-2A visas were issued. And I imagine that number is going to continue to rise. It has risen significantly. The harder that it is to hire U.S. workers, the more agricultural employers are going to have to rely on the H-2A program, which it's a great program. So obviously there's a lot of regulations around it, a lot of requirements around it, but it is a great program. So you want to hire H-2A workers. Let's talk about your obligations in the process. You have to have non-discriminatory hiring practices, meaning you must be open to hiring any qualified U.S. worker, regardless of race, color, national origin, age, sex, religion, handicap, or citizenship. They have to be qualified, though, to perform the work. So this question comes up a lot, which this is really important, because what happens when you file an H-2A application is, since your job is public, you will get oftentimes resumes from non-U.S. applicants, meaning some guy in Brazil found your information and sent you a resume saying, I would like to be considered for this job. And that question comes up all the time. Do I have to interview this person? The answer is no, because your requirement is that you be open to hiring a qualified U.S. worker. What is a U.S. worker? So a U.S. worker is defined as a citizen or national of the U.S. or an alien who's lawfully admitted for permanent residence in the U.S. As a refugee, granted asylum, or an immigrant otherwise authorized to be employed in the U.S., or an individual who is not an unauthorized alien with respect to employment in which the worker is engaged. So an example of the last one would be someone like on DACA. They're not technically an authorized alien, but they do have a legal working authorization. So that in normal people terms, this is just anyone in the US with lawful working status. This does not mean someone that is applying from outside of the US. So that's what a US worker is. So when you get the applications from people outside of the US, I like to have people document that they received the application, but whenever you reference the resume, you did not think they were a US worker, and then the reason why. So the reason I like to do that is just in case you inadvertently reject a US worker because you thought they were a foreign national without a legal working status in the United States. In the event of a Department of Labor audit, it's good to be able to reference back to it, like, why did I skip over that person? What happened there? So that the DOL would know it wasn't deliberate. Accidents happen. You might still get fined for it, but at least they would know that it wasn't a willful action. Okay, so now another requirement of H-2A filings, and this all goes back to, is the thing that I'm bringing up H-2A workers adversely affecting the U.S. workforce? And so there's a prohibition against filing H-2A applications where the worksite for which the employer is requesting H-2A certification does not currently have workers on strike or being locked out in the course of a labor dispute. So you can't have H-2A, or you can't have an agricultural employer have workers go on strike and then file a temporary application because, hey, my workers are on strike. I need H-2A people to perform this work until my workers come back. You can't use them to just replace your U.S. workers. So yeah, this is the regulation. So employers can't replace striking workers with U.S. workers or with H-2A workers. Okay. Recruitment requirements. For those of you that have been using the H-2A program for a while, you probably remember whenever the H-2A rules required that you post newspaper advertisements. I think they stopped that in 2019. And I, for one, as someone that files these applications and had to place all those advertisements, and extremely grateful for that. Of course, they've made other parts much more difficult, but they have getting rid of this requirement has been a big deal. It's also been a big cost savings for employers, particularly ones that file large numbers of labor certifications. They used to make you post newspaper advertisements in various newspapers, but they don't do it anymore. Instead, they require you to continue to work with the state workforce agency by accepting all referrals of U.S. workers who apply consistent with the 50% rule, which we'll get into in just a minute. But yeah, whenever you get referrals from the state workforce agency, take it very seriously. Call and document your correspondence with the U.S. workers. There have certainly been times where U.S. workers have abused their knowledge of the H-2A rules. So be very, very careful with how you document that, and particularly if you're rejecting a U.S. applicant. And of course, hire any able, willing, and qualified U.S. applicants. That's part of the H-2A regulations. And if you have a problem with hiring people, which is the reason you're using H-2A to begin with, it still solves your need. So there's no harm in hiring them there. Yeah, just as a precautionary note, the DOL still has the authority to require newspaper advertisements or other forms of positive recruitment, and you'll be able to see these in your notice of acceptance. If we file your applications for you, this is something we look for in all of our notice of acceptance, but if we don't, just be sure to pay attention to your notice of acceptance to make sure that you're abiding by the requirements of the notice of acceptance for recruitment. Now, this is a big one. And so sometimes this one comes up and the employer didn't mean anything malicious by it. But don't hold or confiscate your workers' passports, visas, or other immigration documents. You can just take them to get a copy of them. So you have a copy of them, then give your employees back their original. If they ask you to hold on to their passport, don't hold on to their passport. This is particularly a problem if there was an allegation. Now, it wouldn't have to be true, which is why I say, even if they ask you to hold on to their passports or visas, don't do it. Make them be responsible for their own passports and visas. Because if they gave you their passport, they said, hey, will you hold on to this? And then they get mad at you. And so they call the Department of Labor and they tell the Department of Labor, hey, I want to leave. I don't want to work here anymore, but my employer has my passport and visa and they won't give it back. This is a serious criminal violation. So do not hold on to their passports or visas, even if they ask you to. Be very, very careful about that. I've heard of it where the employees wanted them to because, they're staying in a motel. The cleaning staff comes into the motel. They don't want to take their passport with them to the work site. So they want to leave it in the motel, but they're kind of scared it's going to be taken or stolen. And so they want their employer to hold on to it. It happens all the time, but don't do it. Don't do it. It's not worth the risk for you. The job opportunity must be full-time, aka at least 35 hours per week. And then you can't have had recent or future planned layoffs. Okay, let's talk about what is the 50% rule, which is what I referenced on the last slide there. So the 50% rule requires employers to hire any qualified, able, and willing U.S. applicants from the time the foreign worker departs for the employer's place of employment until 50% of the period of the work contract has elapsed. Now, this means that if you have a certification that's 10 months, your workers get there on time. 5 months through, 5 months through, you need to update your recruitment report, which is called your 50% recruitment report, to reflect if there have been any new applicants and what happened with those applicants. If someone hires after that 5th month in this circumstance, you're not required to hire them because you're 50% through the work contract. So that's what the 50% rule is. And this has happened. It's very rare, but it has happened a few times where employer brings up all the workers. I petitioned for 10 workers. I brought up all 10 workers. I have work for 10 workers, which is why I petitioned for 10 workers. A month into the work, I have a U.S. applicant call and they want the job. They're able, they're willing, they're qualified, they're ready to go. But I have all the positions filled. What do I do with my H-2A worker? This is called displacement of an H-2A worker. And then the employer is not liable for payment of the 3/4 guarantee, which is a whole other issue that we'll get into in a future webinar. But just know for now, employer is not liable for the 3/4 guarantee to an H-2A worker who the CO, which is the certifying officer of the Department of Labor, certifies as displaced, because the employer's compliance with the 50% rule with respect to referrals made during the time period. So what does this tell you? This tells you to not just send the worker back and say, okay, I'm done with that. It says worker whom the CO certifies as displaced, meaning you have to petition to the Department of Labor to tell them this is what's happened, have them approve it, and then displacement of the H-2A worker, you'd go through the proper reporting requirements. So work with your attorney or agent if that circumstance comes up to make sure that you're doing it properly. But that does come up occasionally, not a lot, but it is something to be aware of. So, and then you also want to pay attention to that 50% mark, because you want to know that you are updating your recruitment report timely, which if you're one of our clients, we do it on your behalf. Okay, here's a loaded one. No unfair treatment. An employer cannot use H-2A workers to replace similarly employed U.S. workers in the occupation in the area of intended employment that were laid off within 60 days of the date of need, unless the similarly employed workers were laid off for lawful job related reasons. So let's say that you have a crew of U.S. workers that were laid off because they were stealing from you right in the middle of your season. You don't normally use the H-2A program, but you laid them off because they were stealing from you. It's well documented. Well, that's a lawful job-related reason to lay someone off. So you can bring up H-2A workers to perform that function. The important thing there, just like with most other things, is to have this well documented. You can't just willy-nilly say, oh yeah, no, I fired them for good reason, and then not have anything documented. Make sure it's well documented. That's very, very important with everything as it relates to H2A, because the Department of Labor likes to see that. So if the employer had laid off within 60 days, you must extend offer to all those laid off prior to using the H2A worker to fill that occupation. Yeah, so if you, which you do this is part of the recruitment process as well. On your recruitment report, you have to say if you advertised the job or offer the job to any workers that you laid off. And then if you did, what happened? Did they respond to your email? Did they accept the job? Did they reject the job? You have to put that in your recruitment report. So do not intimidate, threaten, restrain, coerce, blacklist, discharge, or in any manner discriminate against anyone, but especially if they filed a complaint against you with the DOL. Cause a DOL audit of your company, testified or about to testify against you, consult with a legal assistance program or an attorney about their rights, or exercise or assert on behalf of themselves or anyone else any right protected under the H2A regulations. So what happens a lot of times, and this has been a lot more common over the last couple of years, is the Department of Labor, actually not the Department of Labor, the state workforce agencies have been coordinating with employers to tell the employees of their rights under the H2A regulations. Normally when the workers first get up there, very common, state workforce agency reaches out to you. State workforce agency says, hey, I want to talk to the workers. They have every right to do this, so don't stand in their way. And then whenever they do, they go talk to the workers, tell them, hey, if you have problems, contact me. Let's say that you have a worker that does contact them to complain about some aspect of the job. Don't start mistreating the employee as a consequence of that, because it'll make it far worse. Okay, recruitment requirement. As it relates to H2A, as a general rule, H2A workers don't pay for hardly anything except for their own food if they're given free and convenient kitchen facilities. But make sure and document that your workers do not pay you or anyone else for the opportunity to obtain an H2A visa. They cannot pay your attorney's fees. They cannot pay your certification fees. They cannot pay to be recruited. You need to, this is important. There's no knowledge requirement, meaning the Department of Labor comes in and they're investigating you and they learn that your workers paid to be recruited for the opportunity to work on an H2A visa. They paid the person that recruited them. You didn't know. This was a trusted employee. This was a family member. You paid them to recruit, so you just assumed, hey, they didn't get paid by the workers to be recruited. That wouldn't make any sense. But come to find out, each of your 50 workers got paid or paid this person $1,000 each for the opportunity to work on an H2A visa, because after all, they're making as much per hour here as they made per day back home. So what happens? Department of Labor finds this out, hears about it from all 50 employees. They hear all 50 employees paid $1,000. Employer had no knowledge of it. Well, what is that? What happens to you in that circumstance? In that circumstance, what happens to you is Department of Labor fines you potentially for each person that paid to be recruited. So 50 separate fines of about $2,000 each. If the DOLs, if they're nice, I think it's about 1,800, but we'll call it 2,000 because I'm a lawyer and we're not good at math. So $2,000 each, you're looking at $100,000 in fines. And then you also have to pay all those back wages, $1,000 a person times 50 people, $50,000. You're looking at $150,000 issue there. If you're lucky, you can negotiate it down with the Department of Labor. There's no knowledge requirements. So this is you didn't know, you didn't do anything wrong. But what you didn't do is you didn't get a contract with the people that recruited your workers and you didn't get a contract or you didn't get an acknowledgement from each of your workers that they did not pay to be recruited. So what we like to do is, one, if you use a recruiter or anyone in your business, just have them sign something saying, in accordance with blah, 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 you're not being paid by any of the workers to recruit on our behalf. When the workers get there, when their workers get to the place of employment, have them sign something also that says, we didn't pay to be recruited. When the workers leave, have them sign something that says, of course, assuming it's true, that they didn't pay to be recruited and that they were paid all wages to which they were entitled, at least that they know of. This will help CYA in the event of a DOL audit. And this is one of the biggest deals that DOL really doesn't like this. So this is something they will ask about every single time in an audit. So just have that signed. It'll make your life a lot easier. You have to put up posters with worker rights and housing and at the job site. At the job site is usually the trickier one. So there's a few ways you can do it. You can, if your workers have a trailer, like a tool trailer or anything like that, stick it in your tool trailer. Stick the posters in your tool trailer. If they travel in a van or a bus, put those posters in the vans or on the bus, just so it's at the work site. If they have a porta potty there, put it in the porta potty. Any of these locations are good, just so they know the poster's there somewhere at the work site where they can see it. Just stick it on something where they'll be able to see the poster. Same thing at the housing. And the posters need to be in a worker's language. It needs to be posted in the housing and at the work site in a conspicuous place. This is also something DOL will ask about. I was actually talking to a DOL investigator yesterday. And he says that this was one of the biggest problems that H-2A employers have is they're working in a field. Where am I going to post this at the work site? And so his recommendation was always in the vehicle, if possible, and then or in a porta potty if it's not possible. So, all righty. Well, those are the slides. Let me turn off my sharing here. Oh, I'll turn off the sharing. Oh, stop here. Oops. Okay. All righty. Looks like, and so we can move on to Q&A. If you have Q&A questions, feel free to stick them into the Q&A, and I will be more than happy to answer any of those. Okay. First question. For an H-2A truck driving petition, the driver must stay on farm road, or can they drive on the highway to deliver commodity to the farm company delivering packing house? So this is the H-2A truck driving petitions are particularly sticky, and that it takes a lot of detail for me to be able to answer questions about that. But I'll tell you, if you're a farmer and the truck driving is being done as an incident to or in conjunction with your own farming operation, then it's fine, because you're meeting both elements. You're meeting the work that's done by a farmer, at least by your employees, and then you're meeting the requirement of as an incident to or in conjunction with the farming activities. Now, if you're a farm labor contractor, that's not the case, and then they look to, well, where's most of the work being done? That's how they look at it. But if it's mostly truck driving, it's usually not allowed. The other thing to be aware of, if you are a farm labor contractor and you are, if you're a farm labor contractor, if you are not a farmer and you have work that, so let's say you're truck driving, so you're kicked out of FLSA. You're not a farmer, so you're kicked out of FLSA, you're not performing agriculture. Remember that the exemption for overtime is found in the Fair Labor Standards Act. And so the potential problem that presents is that if the Department of Labor comes in and they find out that the work that you're performing is not FLSA agriculture, then there's going to be a potential large back wage issue in that overtime calculation. Of course, that just so everyone's aware, agricultural work is exempt under FLSA. So you would need to meet the definition of agriculture under FLSA. But that's also subject to state laws, because sometimes states also require overtime, such as, Minnesota's after 48 hours. California's got kind of a scale. Washington has H-2A overtime. So let's see. Okay. When a company becomes E-Verify, can we terminate E-Verify process after a year? I don't know a whole lot, to be honest, about E-Verify regs, but as a general rule, I have been told by other employment lawyers, when you start using E-Verify, to not just stop using E-Verify. That I don't know the specific. I wish I could help you out there. I'd be happy to look into that for our next webinar, but I don't actually know the rules for E-Verify. Because of the wheat case, are CDL drivers not allowed with H-2A? This is a great question. And so it says, because of the wheat case, are CDL drivers not allowed with H-2A? CDL drivers may be allowed with H-2A. Now, we filed plenty of applications where having a CDL is required. But it's going to be very specific circumstances. It's not about the possession of the CDL. It's about the definition of agriculture. And is your work that you're performing agriculture? Is it, is it primary agriculture being things that you would associate normally with agriculture, the harvesting of crops, the production of crops, tilling fields, raising of livestock, the things that are always considered agriculture. And then if it is not one of those things, it is the work you're performing on a farm or by a farmer as an instant to or in conjunction with that primary farming activity. So is it being performed on a farm? If no, then it better be being performed by a farmer, because otherwise it's not FLSA agriculture. Is it safer to do a separate petition for team leader and equipment operators from a regular labor petition? This is a great question. Actually, all the questions have been great, but this question is really interesting because of where we are right now. So first of all, yes, if you have people performing separate job functions, they need to be on separate applications. And this is going to become particularly important because of the current proposed rule change that's going to change the methodology by which the wage rates for certain agricultural occupations are determined. And what you don't want to do is you don't want to loop someone in with a different petition and then realize that they should have been at a different wage rate. This is going to be one of the complications that comes up whenever that rule becomes final, which that rule probably won't become final until the end of this year. But that is going to be a complication because one, having an equipment operator with a harvesting crew, you might be on separate wage rates, especially if they're also driving trucks, because it's definitely going to put them at a much higher wage rate. So yes, it's safer even now, but it's going to become critical in the future because they could be at different wage rates. I'm curious about the sectors. Okay, so where can I find information about visas issued? I'm curious about the sectors are hiring and if there are trends happening. I can send out data on that. That DOL releases data quarterly about who filed H-2A applications, what sector they're in, the percent in each sector, that sort of thing. I can send that out. I just got it 2 or 3 days ago, so I'll be happy to send it to you. Okie doke. Does the 50% rule apply for H-2B, the recruitment requirements? So this is a separate question. So H-2B, just for anyone that's not aware, H-2B is kind of the sister visa of H-2A. It's for non-agricultural work. There is a numerical cap on it of 66,000 annually. It's really competitive. And so this question is about the recruitment process. The recruitment for H-2B workers lapses before the job actually starts. So the recruitment process is a bit different for H-2B. Any way to have workers here for more than 10 months? Yes. So whenever we're talking about the seasonality of a job, we're talking about the seasonality of a specific job opportunity. So if you're looking at how to have workers here for longer periods of time, it's very important to dissect the nature of the specific job opportunities and to make sure that they are different if they are for more than 10 months. But the seasonal component is for a specific job, not for you having H-2A workers. That's a really common misconception, and but that part takes a lot of strategy. So it'll be very factually intensive, very circumstantial, but yes, there are ways to have H-2A workers generally for more than 10 months. And it's not uncommon for large producers in particular to have workers for longer than that for separate job functions. It's totally normal. How does the new CDL rule affect farmers? So that the new CDL rule, I'm not sure if this is related to, I know there's a new CDL rule about the testing requirements for CDLs. I don't actually know the specific testing requirements, and I imagine they would vary by state. I'm not sure if it's referring to that or if it's referring to the new rule, the proposed rule change as it affects the wages of agricultural workers. So what farmers used to be able to do is okay. Will someone put in the Q&A real quick if they can hear me? I just want to make sure that you can hear me. I'm seeing these muted ones, but I think that might have been when my computer crashed. I just want to make sure. Okay, cool. Thank you. All right, let me go back to that question. So, cool. Okay, yeah, so the CDL. What H-2A employers, particularly farmers, used to do is they would just put everything on their one H-2A application. Now, the new wage rule that is going to come out at the end of this year will make a big difference for farmers as it relates to their truck driving. They're going to need to separate their applications. They're going to need an application for the actual truck driving, and then they're going to need an application for the harvesting of the crop, because it's going to be significantly different wage rates. It's one of the biggest problems with this this new wage rule is not only that the methodology by which they're calculating the wages is just asinine, it makes no logical sense, but it also is going to make the application process more regulatorily burdensome and expensive. So it's a very frustrating thing, and and all of that was reflected in our comments to the proposed rule change, which we submitted on January 30th. So it's frustrating though. So we can keep you updated on the progress of that though. After I submit my recruitment report showing no U.S. applicants, what's the next step in bringing H-2A workers? So you should get certification from the Department of Labor, and whenever you do, you file the I-129. Okay. If the workers sign the contract stating they didn't get charged or charge anyone to be on contract, and the FLC finds out they did charge workers to be on the contract, what's the FLC liable for, and what steps should the FLC take? Okay, so workers signed contract, recruiter signed contract saying we weren't charged. FLC then subsequently finds out everyone was lying to them. So and by the way, sorry, FLC stands for Farm Labor Contractor. Basically, anyone that's performing work on a farm that's not their own farm, or at least a farm that they operate all of the operations of. What steps do you take? So if that happens, first of all, you need to investigate it yourself. I wouldn't just take anyone's word for it. I would investigate. I would question separate workers to make sure that it's true. And then if it is true, you need to pay the workers back. That'll avoid you being fined because you went through the process yourself. It'll also, and then make sure everything is well documented, but you are still liable to pay the workers back for that. But the reason that you get the contracts is because of between the recruiter and the workers is because it provides a document trail for reliability of testimony. So if a Department of Labor investigator came in and they said, hey, these workers say they were all charged for the opportunity to work here, your recruiter says that they charged them, and then you say, well, I've got contracts from them when they got here, when they left, and from the recruiter, all this said they didn't. You've definitely got some really good impeachment evidence if you wanted to appeal the Department of Labor's determination that you were that your workers paid fines, because the burden of proof is on the Department of Labor to establish that your workers paid that fine. And so one way to make it harder for them to overcome that burden of proof is to have evidence to the contrary. That's why you do it. Can a subcontractor apply for a bus driver on an H-2A petition? Subcontractor is in a farm labor contractor. So, and then the bus driver on the H-2A petition is only doing bus driving. Under those circumstances, that would not be an agriculture, because it's not work that's being performed on a farm or by a farmer. And so it wouldn't work. If you were the farmer, you could. All righty. Okay, so this question is, if I have H-2A workers currently in one role and we transfer them to a new role, how long can they remain in the US before they have to return to their home country? How long do they continue to transfer roles before they must return? So first of all, you'd want to make sure that the worker that's going from one role to the other role is qualified to go from one role to the other role, meaning they have the experience requirements, the lifting requirements, any of the requirements that you had on both applications. Make sure they're qualified to transfer to both so that you can show that to the Department of Labor in the event they asked. So that's the first thing. But now to get to the actual question, which is how long can they remain in the US before they have to return home? Theoretically, 3 years. The workers under the H-2A regulations have to return or leave the country for 90 consecutive days every 3 years. And if you had separate roles, which they were qualified to take, and they are in the United States for that duration, they can transfer back and forth until then. Okay. This is an interesting question. So it says on a ranch, work hours fluctuate. Just so everyone's aware, whenever you're applying for H-2A visas, you're required to show what your ordinary schedule of operations will be. It just says this time to this time, these days, this many total hours in a week. It's used to determine your 3-quarter guarantee. So it's a important thing, but ranch hours fluctuate. All agricultural hours fluctuate. That's totally normal. And the DOL doesn't allow 24/7 for non-open range applications. That's all correct. Do I just put any normal schedule and hopefully not have issues if the workers do not follow the schedule? Yes, you put your ordinary schedule of operations, your anticipated schedule of operations, and then you're allowed to offer workers beyond those hours the offer hours beyond that. And I've never seen H-2A beyond the schedule. I've never seen H-2A workers complain about that because they generally want as many hours as humanly possible. So that's not an issue. But the potential issue that arises for you is that you don't want the number of hours that you're offering to exceed 120% of that is disclosed on the work contract, because the DOL in that circumstance would make the argument of, well, you should have put more hours on your work contract because a U.S. applicant might have taken it, because then they would have calculated how much they would have made over the course of the week. It's not true, but that's what the DOL argues, and they'll try to find you on that basis. how do we find out which states require overtime for H-2A workers? You can Google it. Just look up overtime, or state overtime requirements, agricultural workers. But I can also, let me just pull some of them up for you real quick. So the states that require overtime for agricultural workers in some capacity are Washington, California, Minnesota, New York, and Maryland, and Hawaii. And then, just so you know, another potential issue comes up with overtime is because you need to make sure that your workers are exempt based off the definition of agriculture in your state as well. And I'll give you an example. The definition of agriculture under most states just adopts the definition of agriculture under FLSA. That's how most states do it. In Illinois, for example, they have the definition of agriculture under FLSA adopted, but they provide for a specific exemption for contractors that are performing construction on a farm, but it's not their own farm. And so while that's normally recognized as FLSA agriculture, because it's not under Illinois laws, those workers would be entitled to overtime beyond 40 hours. So if you're performing normal agricultural work, say harvesting of crops, whatever it may be, the normal rule is it's any of those states. But just be careful based off the definition of agriculture in your state as well. If H-2A workers are going to be driving ranch vehicles in towns, should they get a U.S. driver's license? Yes, unless their license is recognized here in the U.S., like certain commercial driver's license from Mexico, they should get a U.S. driver's license. Under H-2A petition, the wage rate can change for team leaders and operators. That's the question. Right now, it's not. Right now, all agricultural workers are paid the average effective wage rate, but that's going to change here at the end of the year whenever the Department of Labor adopts the proposed rule change. Someone asked if I'll help them evaluate if their employers qualify for H-2A. More than happy to. Feel free to send them over to us. I'm more than happy to talk to anyone that's wanting to know if they can leverage the H-2A program. H-2A is one of my favorite things in the whole world. So yeah, feel free to send them my way. How many times can a worker be transferred from job to job once they arrive? There's no limit. 3 years. They need to be out in 90 days, but they can go from petition to petition, I mean, all the time. Now, with H-2A applications, when they're being transferred from one employer to the new employer, they can't start work for the new employer until the petition's approved, not once it's submitted to the USCIS. So that's something to know. Okie doke. I'm going to get to these last few here. With workers required to have an FLCE card to be able to consider drivers, with them doing a DOT physical and most likely having to drug test, does this require the FLC to test all of their employees? No. But yeah, this does bring up a good point. The Migrant Seasonal Worker Protection Act has requiremms for who's allowed to transport migrant workers, and you want to make sure you're in compliance with those. So FLCE card is the gold standard, I guess, for making sure. So this question, this is a great question. How could you get H-2A workers for a dairy? What ways, if any? What jobs? There's a lot of ways to get H-2A workers for a dairy. And I would just have to talk to you specifically about the operations of that dairy and the data that we'd be able to provide to demonstrate the seasonal nature of certain occupations on that dairy. And remember, the seasonal definition is labor levels far above those necessary for ongoing operations. So that doesn't mean, I mean, there's circumstances where milkers are seasonal. So just, if you reach out to me separately, I'll be more than happy to talk you through how we can evaluate if H2A workers would be able to work on a dairy farm. Remember that the burden of proof in establishing your eligibility as an employer is on you to get the certification. And so a lot of it is based off of the evidence that you have to substantiate the nature of the seasonal need, but I'd be happy to help anyone evaluate that. That's my favorite thing to do. I love H2A. I love going through the strategy process. It's so much fun to me. So feel free to reach out to me. If the worker found someone to expedite the process of getting a visa and they charge them, do we pay that? Yes, workers cannot be paid for any portion of the visa acquisition process. The only thing that they can pay for is getting their passport, and that's because that is to their own benefit, and it's not necessarily to your benefit at all, and they could use it for a lot of other things. So aside from the passport, everything else needs to be paid for by the employer. This is an interesting question. If a worker's reached a 3-year limit and left the United States for his 90-day reset, so they were gone for 90 days, would he be stopped from entering the U.S. if he tried to come back before the 90-day period? Probably not, because the CBP records are atrocious as it relates to workers leaving and coming back. So probably wouldn't, but to maintain compliance with the H-2A regulations and to avoid issues whenever you're actually transferring the worker from one application to another, if that's going to happen, I would make sure that they still stay out 90 days. It's just safer. So someone put in the message that Washington is for the overtime. Thank you for putting this in. I'm not super familiar with the Washington overtime rules, so thank you for putting that in. Washington's in a phase-in period for overtime. So this year it's over 55 hours, and I think it gradually, I think over the next few years, it gets less and less. With turning in applications for a worker to receive a FLCE card to be able to drive the vehicles, they're required to have a social security number. We've called over 60 social security offices and they seem to all be closed. What do we do at this point if we can't schedule social security card appointments to receive social security cards? So what I would do, make sure that that's well documented. This is, this is kind of where practicality meets compliance, and it's definitely an issue. Another issue is how long they're taking to issue the FLCE cards. I mean, you're talking about 16 weeks for those things, and even longer, 16 to 18 weeks right now. So but I would make sure that the worker goes through all the other parts of the application already, make sure they do their physical, make sure they have a valid license, all that kind of stuff, and then submit the FLC application just as soon as you possibly can. And you have to just keep trying to get them in to get their social security card, and that's really all you can do. Are we required to withhold state and federal taxes from H2A workers? Whenever my clients ask me this question, I always tell them to ask their accountant, because I'm not a tax lawyer, so I don't want to give bad tax advice. But I will tell you, it's my understanding that's voluntary for H2A workers, and that they can say, don't withhold taxes from me. But I believe under the Internal Revenue Code that a lot of times these H2A workers, because they'd be here for more than 180 days over the course of the year, that they would be considered residents and subject to federal and state taxes. So then if they file their taxes, they would actually maybe end up owing taxes as opposed to getting a refund. So as a practical matter, a lot of times it's good if your guys will withhold their taxes, and then they can file their taxes and get any money back that's owed to them. That's going to depend in part how long they're here. When recruiting workers in Mexico at location for general qualifications, is the company responsible for paying the workers for travel to location to pre-apply in their country? So technically, no. I'm assuming that basically what workers are doing is they're going from one location to this location to demonstrate to this employer that they are qualified for the application. That's what I'm assuming. So let's say I'm a agricultural construction company and I require that they be able to use a tape measure. And to demonstrate this to me, they can send me a video or they can travel to this place to show me they know how to use a tape measure. The cost for traveling to demonstrate they can use a tape measure, that's not required to be paid by the employer. Are there any other options than FLCE cards to be compliant with being drivers? Yeah, sometimes you aren't required to have an FLCE card, so you just need to go through the other processes like having your vehicles inspected, getting medical cards, all those sorts of fun things as it relates to MSBA for them to be compliant drivers. But it depends. If you're a farm labor contractor, then no, they need an FLCE card. Is there any specific documentation that needs to be filled out to show a worker transferring to another petition is qualified? If not, should we at least document their experience, make sure they're qualified to keep an employee file? It's okay just to verify that on your end. So you don't have to submit that to the USCIS to demonstrate that they're able to go from one application to the other. It's something you want to maintain internally on their employee file and make sure that you are just holding them to the same standard you would hold US applicants. So if your vetting requirements for US applicants say, I'm going to call past employers, I want to see pictures of you performing this job function, I want to see a resume, you do all that, you need to do that with your H2A workers. If your internal practice is to take the person at their word, then that's all you have to do with the H2A workers, but be sure to document it. Document. Okay, so I got a message from someone here that said that they used to work at the Social Security Administration and they're trying to work through some of the processes. And their advice was to call the local offices and not just the general line. So if you're calling call the specific offices, and you might get a little bit, you might get a little bit better response. Okay, and then be sure to get your workers their Social Security numbers whenever they get here. And then, yes, okay, so someone sent me a message that said there's a document that the IRS explains it. Thank you for pointing that out, that they'll send it over in Spanish and English. I have that too. But yeah, if you'll send it, great. I think I have it too, though, and I can forward it out to everyone that participated here. Okay, so are there any other questions that y'all will want to go over? If you do, just pop them right there in the Q&A. I'm glad to hit any other ones that are around. Nope. Okay. All right. Well, hey, I appreciate everyone participating here. I really appreciate the Q&A. I love the Q&A section. That's always fun for me. We're getting back into a rhythm of having these pretty regularly. So if you have H2A questions that come up that you want me to answer on the next webinar, just feel free to write that down or shoot me an email. My email is kyle@farmerlawpc.com. And I appreciate everyone participating.